My name is Richard Susskind, and the Canadian Bar Association has asked me to talk for about 20 minutes on my views on the future of legal practice and legal service. It's a tall order because it's been about 30 years of work that I have devoted to this subject. But what I thought might be best to start with is the point of view of the client. And I'll start, when I talk about the client, with the general counsel, the in-house lawyer. In-house lawyers today are telling me three things. They're telling me, first of all, that they're under pressure to reduce their own internal headcount, to reduce the number of people they have in their team. They're telling me, secondly, that they're under pressure to reduce the amount they spend on external law firms. And thirdly, they're saying to me they have more legal and compliance work to do than ever before. Now, this seems to me to give rise to a very, very challenging problem. I call this the more for less challenge. That basically clients are saying to law firms, we require more service at less cost. And if we're honest, it's not just the very large organizations with general counsel who are saying this. Right down to the individual consumer, the person in the street, everyone seems to require more legal service at less cost. So how do we meet that challenge? For me, it's the defining challenge of the legal profession in the coming decade. And the techniques we adopt, I think, need to be quite imaginative, innovative. I suggest really there are only two broad strategies for meeting the more for less challenge. I call this the efficiency strategy and the collaboration strategy. The efficiency strategy said we need to cut the costs of legal service. The collaboration strategy says actually clients might quite usefully come together and share the costs of legal service. So cut the costs of legal service or share the costs of legal service. They seem to me to be the only options. Let's dig into each in a little more detail. As for cutting the costs, what I'm not saying here is simply that we must, as law firms, run tighter ships, that we need to reduce our overheads. Of course, all of that's important. We have to make sure we don't spend excessively in our infrastructure and our administration. But I'm saying something far more fundamental than that. I'm saying, and this is really underpins all my work and thinking in the world of law and technology, I'm saying that there's a great deal of routine and repetitive work that goes on in every law office around the world, from the largest, most complex matters through to the smallest, even trivial matters. There's a great deal of routine and repetitive work that could be done differently, and we have to do that work more efficiently. So when I'm saying cutting the costs, I'm talking about cutting the very costs of conducting legal work itself. And I'll give some examples of that shortly. But it leads me to discuss what I call commoditization of legal service, and also introduces me to this idea that I call the multi-sourcing of legal service. I'll say a little more about that in a second. That's the cutting the cost of legal service itself. The collaboration strategy, the sharing the costs concept, might seem even more radical. This is the idea that clients will actually in some way share their investment, share their expense on legal services, and in that way reduce their overall expenditure. And I believe this will be enabled by a bundle of existing and emerging technologies, collaboration technologies, online community technologies, all of these technologies which will bring people together and allow them to share ideas and insights and experiences in a way that simply wasn't possible in the past. So I'll talk about that in a little more detail in a few minutes' time. Let's turn back to the efficiency strategy and talk about commoditization. In my book, The End of Lawyers, and it really is a question mark at the end of the title, I suggest that legal service is evolving through 5 stages. I call these the bespoke stage, the standardized stage, the systematized stage, the packaged stage, and then the commoditized stage. Now, what I'm saying here is not that for any dealer dispute, any piece of legal work, you have to think, should it be standardized? Should it be systematized? No, I'm saying something far more, I think, fundamental. What I'm suggesting is that for any piece of legal work, we can decompose that legal work. We can break it down into its constituent parts. And of each part, we should ask the question, what's the most efficient way of undertaking that work?